So good evening, friends, and welcome to our presentation this evening with Louise Campbell. I'm Father Conrad Edwards, pastor here at St. Joseph's, and Marie McNeil will do a more formal introduction, but just want to say thanks to Louise. And thank you if you're joining us online. We've started just about a minute early just to make sure all the connections were working, and we hope this is that you're receiving this on our Facebook and YouTube channels. We are recording this, and we will be able to post it later as well. Again, many thanks for joining with us, and without further ado, I'm going to turn that over to Marie McNeil.
Thank you all for coming out. It's great to see this many faces. We're pleased to be here to welcome you all this evening and to have Louise do this presentation for us with assistance from the Government of Canada and New Horizons Seniors Grant Program. Louise is well known to the parishioners of St. Joseph. She graduated from Port Hood Consolidated. She received her business administration degree from St. Mary's in 1977 and then continued on to Dalhousie, where she completed her law degree in May of 1980. She was admitted to the bar on December 16, 1980. She practiced law with the LeBlanc-McDonald pickup from December 1980 to May 1995, and after which she entered into a partnership with Bruce McKean in May of 1995, working out of Guysborough for 30 years. So in January of 2015, Louise returned to practice in Port Hawkesbury. She was honored to receive her Queen's Counsel's designation on April 2008. Louise is very active in our church community, as we all know, but for folks online who may, she's currently a member of the Parish Pastoral Council. She's on the Vision 2020 Committee. She's chair of the Fundraising Committee. She's a lector. She's an adult altar server, and she's a member of St. Joseph's CWL. She's the proud mother of 2 adult children and a wife to Bill Campbell. So welcome, Louise, and thank you for doing this.
Hello, everyone. If you can't hear me, let me know, and I'll try to speak a little louder. I'm here tonight not to give out independent legal advice to any of you. I'm here to give you an overview on wills, powers of attorneys, and personal directives. All of these 3 documents are important to us, and I'll explain as I go along why they are. I'm going to do my spiel, and maybe at the end we can have some questions if you'd like. I would just ask if you have questions, particular to yourself, personal things, maybe you can call me at the office or we can talk later, but rather than discussing those in a public forum. But general questions, feel free. So I'm going to start by telling you what could happen if you don't have these documents. So let's just start, and I'll use myself as an example. I find that easier. So if I were to die without a will, and let's, for just the time being, pretend I don't have a husband and I don't have any kids. So I'm a single person. I've worked all my life. I'm getting to that age where I'm going to be retiring. And I don't have a will. If I die, the government doesn't take all my property. That's a common question I get, is the government take everything if you don't have a will? No, that doesn't happen. But what does happen is that the legislation called the Intestate Succession Act comes into play, and that dictates what happens with my property on my death. So instead of me doing it myself in my own will and expressing what I want to have happen with whatever I've gathered through my life, this piece of legislation will do that for me. And how it's set out in the legislation. So as a single person with no children dying without a will, it goes in linear style. So your parents, if they're surviving, would inherit your estate. If your parents are deceased, presumably if they are my age, it would go to surviving brothers and sisters or children of deceased brothers and sisters. If we don't have any of those, then it goes down to nieces and nephews, then it goes down to first cousins, second cousins. Again, The point being is that if I, for example, if I didn't have a good relationship with all of my nieces and nephews, perhaps I didn't want to benefit them in my estate. I would have wanted, maybe one of my nieces needs something more than the others. So the point is that I haven't had the ability to direct what I want to have happen with my property. So that's what happens when you don't have a will. The other thing about not having a will is that someone has to come forward to be appointed as administrator of my estate. So again, there's a sort of a list of who would be the first person that would be the closest relatives to me, living relatives in the province. So brother, sister, niece, nephew, depending on where they are. But as an administrator of an estate, when you open an estate, you have to, it's called post a bond. And for those of you not familiar with that, it's like an insurance policy. You literally go to an insurance company and you buy a bond, which can be expensive because I've bought them or I haven't bought them, but my clients have had to buy them to open an estate. And what the insurance companies do is they want you to pay the premium for 3 years starting out. So you have to pay that up front. And you don't get released from that bond until the estate is formally closed. And that's another whole procedure you have to go through to close an estate. And again, as an administrator, you don't have any choice. You have to purchase that bond. So it's more expensive, and I don't get to say what I want to have to do with my house or my rings or whatever. It's dictated by legislation. So that's what happens when you don't have a will. We're going to talk about powers of attorney. Powers of attorney are something that are with us when we're living. I can appoint my husband as my attorney. If I'm in a car accident when I leave here tonight and I'm in a coma, I'm still living, but I can't give instructions, I can't sign documents, I can't do any of those things. Because I have appointed someone as my attorney, that person can step into my shoes and do those things. The not having the power of attorney means that that same person can apply to the courts to be appointed as my guardian. And the legislation was changed about, I'd say it's probably 6 years ago now. And it's quite, to be quite honest with you, I was at that stage in my career that I didn't want to learn how to do it all over again because I knew how to do it under the old legislation. Under the new legislation, you have to have, I think it's 2 medical personnel examine me, declare me not competent to carry on my own affairs. You have to post a bond. You have to give notice to all relatives. You have to file a plan of care is what they call it, as to how you're going to take care of that person. There's a whole bunch of steps involved in it to get the same powers that you would get had you done the power of attorney when you were competent to do so. So it's a very important thing. So I'm going to flip back, and I hope I'm doing this the right way. I'm just trying to encourage you to get these documents done. That's why I started this way. So let's talk about a will for a second. So again, the will is my document saying what I want to have happen with my property. I appoint either it's called an executor or executrix, it's male or female, to carry out my directions. And we always appoint an alternate. So you would appoint, say, your husband, and then an alternate, maybe an adult child, usually not someone older than you, the presumption being that you may outlive them. So you're going to pick someone your own age or younger to do that. And the duties of the executor are to basically, when I pass, determine what my estate consists of. So do I have bank accounts? Do I have investments? Do I own a car? Do I own property? Determine all of that. Pay my bills, whatever they might be, but funeral and testamentary expenses. And then distribute my estate in accordance with the directions in my will. Again, recent legislation within the last 5 years or so, there's a requirement under the Probate Act that if you are appointed as an executor, there's a requirement to go out and buy that same bond that I talked about. Unless in the will you specify that you don't require your executor to do that. And I don't know if I explained that, but the reason for getting the bond, it's a guarantee. So if I'm appointed as executor of an estate, once that appointment comes through, I can go and deal with bank accounts, I can deal with property, I can sign deeds, everything on behalf of the estate. So there's a potential there for fraud. I could decide to sell everything, liquidate the estate, and head off to the Bahamas, and whoever was to inherit, it's gone. So the bond is there to protect against that, to pay those people out. In most wills that I do, since that legislation's come into play, the people who are being appointed under the will, of course, are family members. It's a daughter, son, or husband. So we put in the clause that says we don't require our executor to post a bond. But again, it's something to keep in mind when you're talking to whoever you're talking to about your wills. You can have more than one executor or executrix if you wish. They can act jointly. Some folks do that with their children. If there's 2 children, they'll appoint both of them rather than just appointing one. And they act together. It's not as cumbersome with emails and fax and all that. It's not as cumbersome now with getting documentation signed as it might have been, say, 20 years ago when somebody was in Alberta and the other one was here in Nova Scotia and they both had to sign papers. You're sending them through the mail back and forth. But, we get around that stuff now. So it's, a lot of people will do that with adult children, where they appoint the 2 of them to act together or whatever. I'm looking at the crowd here tonight, and I'm going to mention it, although I don't know if it applies to any of us here. If you had young children, so when we start out, we usually do a will, and particularly when we start having children, because in the will we will set up a trust for our children. So if both mom and dad are gone, there's a trust set up for the children until they reach a certain age, then they will inherit the estate. And until they reach that age, whatever's in the estate is used for their benefit. So usually I suggest somewhere between 22 and 25 before any adult child would inherit the bulk of the estate. But again, it's used for their benefit to that point, and then they inherit. If you're anticipating having debts when you pass, so let's say you have a car and it's going to be, the loan is still outstanding. If you're anticipating it might still be outstanding when you're passing, you want to put in your will how that's to be paid. Because if you've left the Royal Bank account to Louise and there's no other bank account and Sam has got the car, but there's a bill on it, he's not going to be too happy. So you want to make sure that you clear that up in the will, that if there's going to be debts, where's that money coming from to pay those debts out? And then once the debts are paid out, then everything gets divided up. A will speaks as of our death. It really means nothing up to that point in time. It's not recorded anywhere. It's not filed anywhere. When I do wills for clients at my office, when they're done, I give them to them and tell them to put them away somewhere safe. Strong box at home. Some people have safety deposit boxes that you use, but just put them away. But again, your will really doesn't mean anything till you're passing. You can change it as many times as you want, although we get a little nervous if you see the same person coming back every 6 months to change the will, but but yeah, you can change your will as many times as you want. You can do a whole new will, or you can do what we call a codicil to the will, which just changes certain parts of it. So if the person you named as executor, for example, has died, well, then you want to come in and name someone else to replace that person, that sort of thing. As between husbands and wives, or even partners in a relationship, if you hold all your property jointly, so you hold your house as joint tenants, you can put a car in both your names, you name each other's beneficiaries on all RSPs, investments, you have joint bank accounts. When the first one dies, so if I'm in that sort of a relationship and I die, my husband doesn't have to open an estate for me. All of that just flows naturally to him. He would produce a death certificate and all of that would go directly to him. So it would be on his death, then the will would speak. So what happens now? We're both gone. Here's how our assets are distributed. I've had people ask me about will kits, and I'm reluctant to discourage people using them because it almost sounds like I'm trying to draw a business for myself. But there is a but to them. Will kits are fine if you are clear in your directions, if they're properly executed, because I have seen homemade wills where it's really not clear what the true intent was. And that's, that after 40 years of doing this, we hope we're getting it right. So it's far better to get it done right and pay the money to have it done. And I don't know that many people use the will kits anymore, but they used to be very common when I first started practicing. You could buy them at a stationery store and fill them out. But there's been problems with those. Let me see, I had some notes here about wills.
Can I just ask?
Oh, sure.
Talking about the bond, if somebody has a will and you don't specify in it that you need the bond, what about if your will was done before that legislation?
If the will was done before that legislation came into place, then you don't have to worry about that. Yeah, no, that's right. So if anybody's wondering when that time was, I don't know off the top of my head, but you can call me at the office and I'll tell you. But yes, at a certain point in time, and one would hope that most lawyers would be aware of that and would be talking to people about that. There's a couple of things I wanted to mention about just I don't know if it's misconceptions or whatever, but I did have clients come in. It was a partnership, and they just assumed that because they were in a long-term common law relationship, that on the death of one, the survivor would just naturally inherit their property, and that's not true at all, not at all. So if I'm in a say Bill and I are married, we've been living together for 40 years. If I have property in my name at my death, it's not necessarily so that he's going to inherit. My children would inherit it if I have children, or my brothers and sisters would inherit it if I didn't have any children, but he's not going to get it. So I think it's a misconception that's out there, and it's one that we have to be careful about. Another misconception that's out there about wills is that if you name somebody as an executor in a will, they also can't receive a gift under the will, which of course is not correct at all. It's in most husband and wife's wills, you would be naming each other as executor. You'd name an alternate to that person, but then the first person who's going to inherit the estate is the surviving spouse. So, but that was someone argued that point with me one time. So. Again, and this goes back to the homemade wills or the homemade wills. If you're named as a beneficiary in a will, you can't witness the signature on that will. And the reason for that is, and again, use myself as an example, if I'm old and feeble and my mind is not so good, and my niece comes to see me and says, "Oh, Auntie, you need to get a will done. I'll do it for you. Let's do it." And the niece ends up, getting the bulk of my estate somehow. If she's a witness on the will, the assumption is that she has somehow pressured me into doing that. That there's been coercion on me and her being the witness to it. So the beneficiary or a spouse of the beneficiary cannot witness a will. Now, when I do wills, of course, they're all generally signed in my office with two independent people, so that's never going to be an issue. I always recommend to my clients, once the wills are signed, executed, and we do what's called an Affidavit of Execution in the office, and that's just the other person who's witnessed the will with me signs an affidavit swearing that she and I witnessed the will on whatever date it was. And that gets attached to the will, stays with the will. But what I always ask my clients to do when they get home is I call it an inventory, but it's basically a listing. So as between spouses and partners, you know where you bank, you know where you might have investments, what property you own. But for someone who's stepping in, even an adult child who's living away from home, they may not be aware where mom and dad have investments, or who they should call for the insurance, or where the property, where the house, the deeds are, and all that. Just leave a list. So if you want to know where my RRSPs, you call this person. If the insurance company, you call this person. We bank here. Here's the account. Just leave that with the will. And again, I hear the story over and over again about somebody having to go in and go through all mom and dad's papers to figure all this stuff out, and finding, how many times I've heard about people finding insurance papers and they don't know if the insurance is still in place, has it lapsed. So it just saves steps. You can also leave with your will a letter, and address it to your executor or to your children or whoever, saying, okay, my china cups I want Sandra to have, or whatever. Just leave that with it. We don't detail out all that in the will because it can get cumbersome. I did have a client from down Guysville County. She was a single older lady who had worked all her life, but she collected china cups. And she wanted it in her will, so we put it in the will. But her will was about 6 pages long because we had to describe each, and you can imagine trying to describe each china cup separately so you can make sure that the right person got it. Anyway, yeah. So for those sorts of things, if it's something expensive, larger items, put it in the will. But for little items like that, you know, mementos, things like that, leave a letter with the will. And what we say is that's morally binding on the family. They will 99.9% of the time follow those directions. If you want it to be legally binding, you want to make sure that Sandra's going to get the teacups, put it in the will. Okay? Any questions about that? Oh, if you make a will, okay, and again, I'll use some self-example. I'm a single woman. I've made a will, and then Bill and I get married. I need to reaffirm that will. I need to go back and say, yes, I intended the will to be what it is, because it's assumed that on marriage that I'm going to change my will. So you want to make sure that you go back and reaffirm the will, or I mean, you can do a whole new will, whatever, but marriage does create that issue. After the will is made, I should say. Yeah.
Louise?
Yeah, question?
Yeah.
In terms of the wishes around funeral arrangements, is that would that be a letter or would that get put in the will?
I usually recommend to clients that not go in the will, and only because from my own sort of experience talking to clients, they don't look for the will. When someone dies, the immediate thing is it's the grief and all of the preparations for the funeral and all of that. They don't go to try and see a will and see if it's in there. So I usually recommend that they either leave a letter or, you know, have that discussion with whoever's going to be handling those arrangements. Yeah. So I talked about the Intestate Succession Act when I started. I said, you know, if you die and you don't have a will, that's the legislation that takes over. And again, it's just the idea that you're not giving your own directions about what you want to have happen to your property. So again, Bill and I are married, but we don't have wills. I die. The first $50,000 value of my estate, he would inherit. But after that, then it starts to get divided up between the children. So much, depending on how many children there are, it gets divided with them, he gets some of that. Rather than the assumption being that, and I mean, the assumption being that on the death of the spouse, the surviving spouse is going to inherit all. So, and then as I say, once you get beyond, if you're a single person who has the assets and you don't have any children, you don't have a spouse, those are the people that really should be looking at getting wills done, because then you're getting into, you know, brothers and sisters. And if there's none of them, then you're getting to nieces and nephews. And I mean, we all have, well, most of us have come from large families, and we see our nieces and nephews once, twice a year, not very frequently. And yeah, it just gets to be quite an ordeal. I had one of those estates one time where a gentleman had died, and he didn't have any family. He was the only child, I think. Yeah. So it was literally because and he was in a common law relationship. So common law spouse didn't inherit, and the people who did inherit had no contact with this man for eons. But they were entitled to inherit, and unless they renounced their right to inherit, which doesn't happen very often, that's where it went. So that's my spiel on wills and why we could have one. And again, when you go to talk to a lawyer, they're going to talk to you about what your assets are, who your children are, we always have to have the discussion with our clients. So if someone comes into my office and they have 4 children and they're benefiting maybe 2 of them and not the other 2, I always have to ask the question, why? I'm not trying to pry into their personal affairs, but I need to have those notes in my file in case the 2 who didn't get anything challenge the will. And then I have something to go back to and say, well, look, this is what I was told. Maybe the 2 that are getting it all aren't as well off as the other 2. And there's all kinds of different reasons why those things happen. Unfortunately, and you've probably heard the stories, death and money bring out real mean things in people. When you least expect it to happen, it happens.
So just on that, if it's very clear, this friend of mine, if it's very clear in the will that her is the executor, daughter is the executor, mom and dad, or mom just died, dad's dead, the property, substantial property, is to be sold equally amongst, distributed amongst the children. If 3 of them, this is 4, if 3 of them say, no, we're not selling anything here, we're keeping this in the family because it's our family estate, our home, whatever you want to call it, she has the right to carry out the will, correct?
She has to, that's not a right, it's a duty.
It's a duty.
She has to follow whatever the directions of the will. If the directions of the will said sell the property and divide it, she has to do that.
Okay.
And wills get challenged on the basis of the person either being coerced or forced into making, will to benefit one person or another, or they were not competent when the will was made. So again, if we have questions about that, we'll ask clients to get a letter from their doctor, just a handwritten note saying that they're competent to give instructions to do that. And again, I guess it's more, I'm protecting myself as much as anything else in those circumstances where I have some concerns that somebody's being left out. I want to have my notes in my file so that if I've ever questioned about that, yes, I discussed it with them and this is what they told me. It's very hard. It's not easy to challenge a will. I'm not saying it's easy, but we've all, again, heard of the cases where these things have gone through the courts and you end up depleting a lot of the money from the estate to fight it all out in the courts. And nobody comes away happy at the end. Okay, I'm going to move on to powers of attorney. So, a will is with us. Will only speaks on our death, so it means nothing till we die. Power of attorney is a document that's with us when we're living. And again, it's a very important document that we all have. And the reason is we don't know what's around the corner. Health-wise, accidents, things happen. And once you're declared incompetent, for whatever reason, or you're in that coma, as I say, you can't give any instructions to anybody for anything. You can't sign legal documents. And no one can do it on your behalf. You need to have someone appointed to do that for you. So power of attorney is with us when we live, while we're living, and when we die, our power of attorney dies with us. So it doesn't mean anything after death. Because I had people say, well, I have a power of attorney on him. Well, you did have a power of attorney on him, but he's dead now, so you don't anymore. So power of attorney deals with things like banking, property issues, the house needs to be sold or remortgaged or whatever, settling claims, legal disputes, all of those sorts of things. So I describe it as the person is literally stepping into your shoes and becoming you. Now, power of attorney is meant to be used for your best interest. So it's not like the power of attorney or the attorney can just go out and willy-nilly do whatever he wants. He or she always has to be thinking about what's in my best interest in acting. So it's a powerful document. So again, if I use myself as an example, God bless you, Billy, I don't mean any insult here, but I've done this before. So my husband has a power of attorney on me. If I'm in that accident, I'm in a coma, Bill could go to the bank and literally clean it out, sell the house, and again, go off to the Bahamas and find himself a new woman, and I'm sitting somewhere in a hospital. Not that he would ever do that. but it is a powerful document. As a lawyer, I'm comfortable when the powers of attorney are being granted between spouses or partners or children. I have had situations where I've had, again, the frail aunt coming in with the niece or nephew, who's all, and maybe, God bless her, she's always been there with Auntie, but maybe she's just come out of the woodwork and said, you know, just go Auntie and make me your power of attorney. And it can, you know, so the Auntie's at home and she thinks that Louise is doing all the best she can for her, and Louise is going off to the debit machine every so often, just taking some extra cash out because she has to go to the post office. You know, it can be abused. So we have to be careful about that. Again, between husbands and wives, partners, children, it's when we start going a little farther, or we have single people who are, you know, who could be influenced to do things that maybe it's not in their best interest. So that's the power of attorney. It's with us while we're living. It dies with us. We did, well, I won't say we didn't do powers of attorney, but I've been doing wills since I started practicing, but I guess the point was brought home to me. I'm still in Garage at the time, so it probably could be 20 years ago. It used to be if someone was getting to the point where they needed to go to a nursing home, that a family member could sign them in, could, you know, make the arrangements, sign the admission papers, do all that stuff for them. And then the government changed it and said, no, you can't do that unless you have a power of attorney. And at that point, I think I had about 3 or 4 families come to me and say, well, look, we were just going to get mom into the nursing home, and now they tell us we can't get her in because we don't have a power of attorney on her. So they had to, and those were the cases where I made the guardianship application for that family to have someone appointed so they could sign the papers so mom could go to the nursing home. So after that, we started thinking, okay, yeah, this is something we should be talking to our clients about more often, because those things happen. We don't think they're going to happen, but they do happen. You know, I mean, just in the last month or so, I had a family in, and it's exactly what's happened to them. Mom is at the point where she's not competent anymore, and they don't have a power of attorney on her, so they're going to have to take those steps. So it's a powerful document, but it's a very important document. So again, once they're done, I tell people, okay, you've got it done, put it away with the wills, and just relax. You're covered. When we were doing powers of attorney, probably about 10 years ago now, there would always be a clause in it that said that the attorney could give instructions for medical care. So again, Bill could give instructions to my doctors, take instructions from them for my care, all that sort of thing. The government has come out with what they call the Personal Directives Act. And basically what it is another power of attorney, but it just deals with health matters. So you would appoint again, and in any of these documents, I should have said the power of attorney, you would appoint one person, generally your spouse or partner, and then an alternate. You always try to do that so you're covered. In the personal directive, you do the same thing. You appoint one person and then an alternate. And again, they have the ability to make those decisions on your behalf when you can't do them yourself. Place in nursing home, end of life issues, and that's where you want to have a talk to that person about what those wishes would be, because it's not, some people have instructed me to put it right in the documents, but I brought a sample with me tonight. I'm just going to read the wording that we use at the office on it. So again, I'm appointing so-and-so, and if they can't act, I appoint someone else. And you're authorizing your physicians, your doctors, your healthcare providers to release patient information to that person so that they know what's going on and can have a full discussion. You're authorizing them to make decisions on your behalf concerning your personal care, including healthcare, nutrition, shelter, clothing, hygiene, safety. We have a wording in ours that says, I hereby express my wish to die with dignity and not with deterioration, dependence, and hopeless pain. So again, that's your personal preference. If you don't want that in there, we don't have to have it in there. The idea is that you're appointing someone who is going to act in your best interest in those situations. You could put a clause in there that says if you're not sure if Louise can't make those decisions on her own, she would be examined by medical personnel to make that call. So is she competent to make those decisions or is she not? And I like this wording. It's wording that I've had in mind for a while now. I confirm that I believe the attorney appointed hereunder have a genuine concern for my welfare and appreciate that my attorney may have to make decisions regarding my personal care on my behalf. Again, you're acknowledging that the people that you have appointed, you believe are going to have your best wishes at heart. There's different forms of this. I have prepared ones that are more, I guess, Christian orientated, if that's a word I would use. It's quite lovely. I found it, I think it was on a website from Alberta or one of the, anyway, out west somewhere, which had been prepared for Catholics and talked about different things in there. It was quite lovely. It's not one that everybody wants, but it's a nice one. But again, important thing is that you have made that decision to appoint someone to make those decisions on your behalf. We don't charge. I don't charge any more for the second one because I just don't feel comfortable. So it's a will and a power of attorney and personal directive. But the important documents to have. And again, same idea. That dies with me, and then my will takes over for my directions.
Louise?
Yes, sorry.
Can I ask just a little question?
Yep.
We have something called this guardian and healthcare appointment.
Yep.
Is that what the?
That's the same, yeah, they have different names. This was called a power of attorney for consent to medical treatment and personal care. You have that one. Some people call them living wills. So if you hear people talking about living wills, particularly from Ontario, because that's what they call them there, that's really what it is. It's a direction that allows someone else to make decisions on your care and on your end of life care, particularly. Yeah.
Those only,
Sorry.
your personal care directive only comes into effect if a person is no longer competent
Yes.
to make the decision.
Yes. Yeah.
themselves.
Yeah. Both the power of attorney and personal care directive, living will, what you mentioned there, they're only when I can't make those decisions myself. Yeah. As long as I'm able to do that, I do it on my own. It's when I can't. Yeah. For sure. Yes.
Louise, if, like in our case, we live here, but our kids are living away, I'd like, say, to have one of them as a power of attorney. Should I have someone who has an alternative that lives here?
And the wording of that is I nominate a constituted appointed Bill to be my attorney, but in the event he's unable or unwilling to act, so unable would be if they're, for whatever reason, then it's so-and-so. Yeah.
And the executor, the same thing?
And the secretary, same thing. Yeah.
Louise?
Yes.
If I got, like, say, an extension for my will, would I have to tell my children that I wasn't getting them to be the ancestors? I was going to get my niece then to be it.
It's not necessary, no. That's your call. You don't have to, no.
But should they know beforehand?
I think it would be appropriate to tell them you have done a will and that it's been taken care of. It's not necessary for them to, and that's, it's a good point to raise here. It's not necessary for anybody else to know what's in your will. It's your own private business. But it's good for family to know that you've taken those steps, that you have a will in place, that you have a power of attorney in place. If you want to explain to them that you've appointed someone else, you can do that, but you don't have to, no. That's, I think, what I wanted to cover here tonight, and I know I probably went through it fast because I've been doing this for so long, but any questions about any of this, or anything else you want me to expound on? Yes, Paula?
If you already have a will prepared, and let's say you have an executor name,
Yes,
and then you decide that you want to change that,
yes.
do you have to go back to the law office, or can you do some changes yourself?
You would do that by way of a codicil, which is a fairly straightforward document. I would think if you Google it, you'd probably find it. So you say, you basically say, this is the first codicil to my will, which was dated whatever date. I hereby revoke paragraph 2 and replace it with this. And then you would say, I nominate Cousin Boo to appoint whoever.
And can you do that for any paragraph in your will?
You can, yeah, you just want to be careful doing it. The codicil has to be signed the same way, I guess I didn't talk about that. The codicil has to be signed the same way as the will. So it has to, so when you're signing a will or a codicil, you sign it in the presence of 2 individuals who see you sign and then sign themselves at the same time. You can't take the will and sign it and then go next door and say, okay, you sign here now, and then I'll go over here and have a sign over here. Everybody, 3 people have to be present and see the signature on the will. And that has created issues for.
Say if you've got, your will done by one lawyer, or something, and you wanted to do that codicil, could you go to like you or another lawyer?
Sure, yeah. No, you don't have to go back to the same, no. Used to be a practice, I've never done it, but anyway. It used to be a practice that the lawyers would keep the original wills, so you'd have to come back to them. We don't do that anymore.
So the lawyer.
I don't want anybody's original will, sorry.
The lawyer doesn't actually have a copy of the will.
I always have a photocopy in my file. It's the original will, so if a will has to be probated, I guess we didn't talk about that, so Bill has predeceased me, I'm dead, I just died. My will has to be probated. So it's my original will that has to be produced. It can't be a photocopy of it. I shouldn't say can't be. There's a process where you can prove a copy of a will. That's a true copy. But you have to produce, you have to convince the register of probate that 1, the will wasn't destroyed. So I didn't tear out my will to destroy it. And 2, that I never intended to revoke it, that it's been misplaced or lost or whatever. But it's, obviously it's a lot easier if you just have the original will.
If you had a will done many years ago.
Yep.
And that lawyer is no longer practicing.
Right.
So that he would have had an original copy at one time. What happened to that?
What happened to the copy, you mean?
Yeah, to his copy.
Well, as lawyers, we used to be told that you couldn't destroy a file, which is ludicrous. Because how many files do you acquire over the space of 40 years practicing? A lot. Really, so I have a copy in my file. As long as it's not the original document, at a certain point in time, I'm going to be destroying those files.
So when he dissolved his office, it was probably.
Well, it could have been destroyed, or it may have been that the whoever was still continuing in practice there kept the files, but I rather dealt with, you know what I mean? At a certain point, they're going to be gone.
Yeah.
But you can't, as a lawyer, I can't destroy any original documents, so I would have to look at all the files that I was going to destroy to make sure that there wasn't any originals. But I don't. I've had people ask me to keep original wills, and I don't, because for that very point, I don't know where I'm going to be in 20 years when you pass away. I don't want you having to try and find a will in some closed files of mine, which God knows where they'll be in storage. So, yeah. That's another. I guess that's another thing that can happen. I've heard it happen. As we get older, sometimes we forget where we put things, or we start to have some dementia and stuff. I'm speaking of myself here. I've had people, come and say, like, I know Mom had a will, but we can't find it. And I don't know what the answer to that is, unless you tell the kids where the wills are and they take them and put them away safe themselves, because I've had that happen. Mom moved the papers or whatever, and they can't find the will. Yeah.
So you mentioned the word probate.
Yes.
So if everything is clear cut and everything is okay in your will, my understanding is probate is not involved.
Well, so probate is what happens when somebody dies, and you have to call it probate the will, probate the estate. In Nova Scotia, if I were to die owning property just in my name, so I had a piece of land down in Pregnant Rear, and it was just in my name, wasn't joint with Bill, an estate has to be open for me to transfer title of that property. I can't, there's no way around it. You'd have to probate my will. You'd have to open an estate. And probating the will basically means someone applies to be, so it would be the executor named in the will, applies to have the will proved. So you file the application for probate, the original will with affidavit of execution attached, the death certificate, a form 4424 for registry deeds, and a check. And that gets filed with the register of probate. She reviews it all, as long as it's all in order, she issues what's called a grant of probate. And that's really your document, that's your license to vote. Say, okay, here, bank, I am now the personal representative of this estate. I want the estate account opened. Give me some checks, name the estate so I can pay the bills. Or I'm going to sign the deeds to transfer the property to the kids or whatever. That's the official document. To your point, if, again, I'll use Bill and I as an example, if he's died and I die next, yeah, it's next, sorry. Maybe not. Anyway, if I'm the second to die, my estate would have to be opened, unless I have set something up with my kids. And some people will do that later in life. They will set things up. So we put the property in joint tenancy with our kids. We put our children on our bank accounts as a true joint account, meaning that on our death, that would go directly to them. We name them as beneficiaries on whatever we have. If you can, some people will do that to avoid probate. Then you don't have to probate an estate. If I die and everything's joint with one or both of my children, then it's the same idea. Produce a death certificate and the property just flows directly to that person. But you have to be careful with that stuff. People, it sounds like a good idea, but as you can appreciate, once you sign the deed to put it in joint tenancy with your daughter or son or whoever it is, you no longer have control over that property. It's now owned by 3 people, so you all have to make the same decision at the same time about what happens with it. You also have the issue of, if your kids aren't that stable in life, and there's judgment creditors coming looking for, potentially could claim against that property if one of the children had financial issues. There's all kinds of reasons why you don't do it early, at least. Maybe later on when everybody's settled and there's no fear of those things happening, you can start looking at doing joint deeds for children, joint bank accounts. And I want to, highlight the point of joint bank accounts. There's 2 kinds of joint bank accounts. There's one is a joint bank account for convenience. So again, the elderly mother who can't get out to the bank puts a daughter on for convenience purposes. It just means that the daughter can go and do the banking for mom. It doesn't mean that on mom's death, whatever's left in that account is owned by the daughter. Or you could have a true joint account, which would mean on mom's death, the daughter gets the profit of that money and nobody else. So, because there have been fights over that as well, about whether it was really intended that sort of whoever was the joint on the account will get it or not. And again, as I say, death and money, not good. Yeah. Any other questions? I don't know where we're at the time here.
I have a quick one.
Yeah, no, go ahead. We have lots of time. I just don't want to bore you guys. That's all.
Okay, well, power of attorney,
Yes.
where the husband gives the wife power of attorney, the wife gives the husband power of attorney.
Mhm.
What happens when one of them dies?
That's why you name an alternate. So you name your spouse. Bill and I have named each other, and then we've named an alternate. So if he dies, then if he dies,
Yes.
then the alternate would step in
Oh, yes,
on
okay.
my power of attorney. Yeah.
Okay,
Yeah.
Thank
So that's why you name an alternate.
yes, okay.
I'm trying to think if there's anything else. Bill, you've heard of talking about this lately. Anything else we've missed? Not hearing. Okay, sorry, go ahead, Jerry.
What about enduring power of attorney?
all the powers of attorney that I prepare are enduring powers of attorney, and I think probably at this point in time, 99% are. So an enduring power of attorney means that, so I've made the power of attorney, if I become incapacitated, it's going to carry on even though my head is not with me any longer. We do powers of attorney for limited things. So I'm living here, Bill's in Alberta, we need to sell the house or we need remortgage. He could give me a power of attorney just to deal with that. So it's a limited power of attorney, it's just for the house. While we're selling the house, he can sign papers on my behalf, or I can sign for him, or whatever. But the enduring power of attorney, generally speaking, that all of ours would be enduring powers of attorney. Whether I'm with it or incapacitated, they carry on. It was not uncommon, and again, this is going back to when I first started practicing, that there would be a clause in the power, and it struck me as strange at the time, but there would be a clause in the power of attorney that said that basically I would sort of have to come back somehow and ratify whatever actions my partner had taken under the power of attorney, which doesn't make any sense. If I've got dementia, I'm not coming back to ratify and say, yes, he did everything right. So these days, it's an enduring power of attorney. When we prepare a power of attorney, it's an enduring power of attorney. Yeah, it's there unless you revoke it. I mean, if you get pissed off, if I get pissed off at Bill and say, you're not handling my affairs, I revoke the power of attorney. I can do that. But otherwise, it's there. Yeah. So again, I'm here if you want to ask more questions. It's almost 7:30, so we've been at it about an hour. If anybody has any questions or if I've missed anything, any points, or you need clarification on anything. Okay.
We keep things as simple as possible after someone passes away, is to have joint ownership of accounts and properties.
Yes.
And
Yeah.
cars and
Yeah. So again, it's between partners, long-term partners, or married persons. If you hold everything joint, so you're joint on your properties, house and all that, you can. I didn't know this a couple of years ago, but you can actually have two names on a car registration. Joint bank accounts, beneficiaries on RRSPs, on tax-free savings accounts, all of that, pensions, everything, all is named beneficiary or joint. If I die and that's set up, all has to be done is to produce a death certificate, and all of that flows automatically to the survivor. And then you have whoever the survivor is speaks about what happens now we're both gone. And I guess just on the wills itself, again, it's your directions, what you want to happen with your property. So again, to summarize, the executor determines what the estate consists of, pays the bills, funeral, testamentary expenses, and then distributes the assets. If there's young children, we set up a trust until they're a certain age so that they're not getting $10,000 when they're 18, because we know where that would go, not to their education, I'm sure. But yeah, and there's all kinds of different ways. I think Deacon Berkeley had said something about instructions. Some people will say that just sell it all and divide the money equally. Then there's no squabbling. Some people benefit one child over others because of circumstances in their life, and that happens. Some kids are doing well, better than others, so they do that. You can. I don't use. I mean, it's not my call, obviously, because it's my client's property. But I don't usually recommend a provision in a will that says I leave the house to all 5 kids. Only because it's all 5 kids are probably not going to be using it equally. They're not all living here. You've got one who's here who's taking care of it and going in and checking it every so often or whatever, and it can create friction. It's sad to say, but that's again, I keep saying it, but it's sad how many cases you see of families that you wouldn't have expected the infighting to happen, but it happens. So that is what I wanted to talk to you about here tonight, but I say, if you had anybody, okay, so go ahead.
Under what circumstances should you be updating the will? On time or on changes or what?
Well, generally speaking, we do wills twice, as I said before. You do it when you're starting out in life, you're having kids, you want to set up guardians for the children, you want to set up trust for the children. And then you do it again when they're adults, okay? So you do it in those circumstances. You do it, you would probably change your will if there's a change in the relationship. You know, if your partner has died and you have a new partner, you know, and that can mean a change in the will as well. You really, I guess that my best advice would be, you know, pull the will out every, I don't know, 5 years or so and look at it and think, okay, well, is that still what I want, or is there something there I should be looking at changing? You know, circumstances change for all of us, even with our grown-up children. You know, everything may be fine now, but something may happen tragic in their life, and they need it more than the other child. So there's all kinds of different reasons why you might want to change your will. I mean, I joked about not wanting to see it every 6 weeks, somebody coming, or 6 months changing the will, because that gets a little concerning. But yeah, look at it, I would say, every 5 years or something like that. Or something major changes in your life, I would pull out the will and look at it and just say, do I need to have some changes in here? Yeah. I mentioned about the common law spouses, and again, it's important as we go through life. So if we're going through life and we have two people who've had families and they've got grown-up children and their spouses die and they enter into a new relationship, you want to make sure, I mean, most people want to make sure that their children are still going to be the main beneficiary of their estate as opposed to their new partner. But you may want to, you know, provide something in the will for the new partner. So that would be another reason maybe to look at the will and say, okay, maybe I need to tweak this a little bit, that sort of thing. But, yeah. Yes?
So if parents leave property to children,
Yes.
and they have 5 children,
Mm-hmm.
and so it's left equally between them all,
Mm-hmm.
what do you do when some want to sell, some want to keep?
Okay, there is legislation actually that covers that. Partition Act. The Partition Act is a legislation of the province, and it covers that sort of situation where you've got people who are in common ownership of the property, but they can't agree what to do with it. I think I started an application once, but I don't think we saw it through. In any event, there's an application to the courts. I believe they set up a commission, a couple of commissioners or something to look at the property, determine how possibly it could be divided up 5 ways. If it can't be divided up, what's the value of it? And the people who want to keep the property basically are paying out some sum of money to the people who don't want it anymore. That sort of thing. It's, yeah. And then again, that I guess goes back to my point about it gets tricky when you start leaving property like that to 5 people, because on the best of days, even in a close relationship, you're not agreeing on everything.
That's right.
Yeah.
Thank you.
You're welcome. Yeah. Yeah. Okay. Well, thank you all. Oh, sorry.
But if property was left in that situation.
Yep.
If it was left, in the will it states, if we left to this, or after the person dies, the house could go to this girl, daughter, because she doesn't have what other people have.
Right.
If it states in the will that when that person can't take care of it anymore and walks away, wants to go somewhere else, then it states the executor then can sell it and divide it.
Yeah, no, I've seen that. We call that trying to control things after you're gone. And it gets complicated. I mean, yes, I've seen those provisions, but, and if no one's challenging it, and I mean, to me, if you're leaving some property, and this is just me speaking here, if you're leaving property to someone, you're leaving it to someone. If they choose to live in it for the rest of their days, fine and dandy. If they choose to sell it 5 years down the road, well, fine and dandy. I mean, that was left to them. It's just, it just complicates matters more when you start trying to extend it out and saying, okay, if he doesn't use it, it goes here or whatever. It's just you're trying to control the life when you're from the grave. It doesn't work. Thank you all.
Thank you very much, Louise. That was really informative and raises all kinds of questions. Go home and dig the willow thing. See what's on it. There is tea and coffee if anybody'd like a tea and coffee before you leave, or if you want to chat with somebody or talk to Louise afterwards in private. So I'll just put the tea and coffee out. Thank you all for coming out this evening.